That is, the people have vested the Supreme Court with the responsibility of interpreting the Constitution.
So why do we have a retention system? Well, why don't we just say, you know what, let the court go for whatever willingness that it might have, because we give all of our power away, we just give to the Supreme Court. So why do we have a retention vote?
That's the federal system that Mr. Tucker currently advocates. And the original colonies, when they became states, all put that sort of system in place. In fact, the first 20 states adopted systems like the federal system, where the judges were given lifetime tenure, and the whole purpose was to accomplish what Hamilton said was important, which was judicial independence. And this effort...
So why do we have retention in the state of Iowa?
Because that is part of the Missouri plan, which is a plan which is intended to reach an accommodation to the concern of people, that they do want to have a voice in the tenure of judges.
So is retention a bad idea?
I have told you previously, I think retention is a wonderful idea. And I think that judges ought to be judged for purposes of retention on their performance in office, which ought to be measured by their competency, their diligence, their faithfulness to the law, the clarity of their decisions, and overall their professional abilities. And it ought not to be a decision which is made, as your group advocates, on the basis of the unpopularity of one decision.
You see, you tend to know more about my group than I do. But I agree with all of the things you just talked about the Supreme Court, but you forgot one thing, and that's what also that they would stay inside of their constitutional boundaries. When they clearly, no, wait a minute, Mr. McCormick, you have to understand this. When you step outside the bounds to make law, there has to be a check and balance. When you step outside the bounds to execute law, there has to be a check and balance. When you step outside of your bounds to amend the Constitution to give rights the founders never could have imagined, you have to have a check and balance, and the retention process is that check and balance. If we're going to allow this form of government to actually exist, and that's why I think it was right when Governor Vilsack got sued for trying to legislate from the bench, and why he lost both times when he tried to legislate from the bench. They held him in check. Governor, I'm sorry. But at the same time, we the people have a chance to hold the court in check here.
I think Governor Vilsack became a defendant in a lawsuit. In fact, I represented the plaintiff legislators in it when he, by executive authority, sought to enlarge civil rights of state employees. You have advocated in your gubernatorial campaign that you would interfere with the Varnum decision by entering an executive order that would attempt to bar its implementation in Iowa. You had no authority to do that. You were way outside your bounds.
Oh, no, wait a minute. First of all, we're not going to debate that issue, but let me try to defend myself here. Article 4.1 says that the chief magistrate of the state of Iowa shall be styled as the governor. Article 4.9 says the governor will see to it that this Constitution is fully implemented in its right order, those types of things. The governor has every right to say, you know what, if the legislative branch is going outside its bounds to execute law, I'll hold them in check. If the judicial branch is going outside of its boundaries to do something they shouldn't do, I'll hold them in check. The same way the legislative branch holds the executive branch in check when they try to make law. Why would that be so uncut? That would have been a great debate, and we would have had it.
That is totally contrary to the provision in the Iowa Constitution, which says that each branch will exercise the powers appertaining to that branch, and none shall infringe the prerogatives of the other.
Exactly. You know what? I wish you could repeat that. Because what it's saying each branch has its prerogative, but it shouldn't go outside of its jurisdiction. What we had here on April 3, 2009, they clearly went outside their bounds. I mean, if I'm a basketball official, I say you're out of bounds, we need to give the ball to the other team. The fact is, they went outside of their boundaries. They should have been held in check, and they will be held in check November 2.
You have reached the conclusion and have expressed the opinion, and apparently have the opinion, that the court exceeded its bounds or its proper constitutional responsibilities. There are many of us that disagree, in fact, emphatically disagree. and believe instead that the court did exactly what courts are supposed to do when they're faced with a constitutional challenge, and it's the sort of thing that the United States Supreme Court routinely does, and did, for example, in the Citizens United case when it was dealt with an issue of commercial speech. Can you believe that our founders back in 1787 considered that the Supreme Court in the year 2010 would be deciding on a concept of commercial speech that it was contrary to the First Amendment of the federal Constitution to require commercial interests that contribute to political campaigns to the court would be ruling on that issue and holding that they did not have to disclose the source of their contribution.